Senior answer.
Oh, yeah.
Good morning, everyone. This is Jenny Pakula, and I'm pleased to bring you a webinar today on a topic that's very near and dear to all of your hearts, independent contractor status. We are fortunate to have Chris Morgan today, an attorney at Barron Lieberman, present an in-depth look at independent contractor status under federal and state law. The program this morning will focus on compliance with IRS guidelines and the state of Oregon's requirements for meeting and maintaining independent contractor status. Chris is just informed me he is, well, an Oregon native, we'll call him an Oregon native, but he is a Washington State graduate. Sorry, Ducks and Beavs, but he does have an affinity for the Ducks, so he's in business. All right, as you all know the drill, send your questions and Chris will answer them throughout the presentation. And here we go. Take it away, Chris.
All right. Good morning, everyone. Thanks for having me. Again, my name's Chris Morgan. I'm an attorney here at Barron Lieberman, downtown Portland. My practice focuses on employment litigation and proactive advice with a specific focus on wage and hour issues, retaliation, discrimination, and those sorts of claims on the management side. So my goal for today is to take a look at independent contractor status under federal, but mostly state law, to give sort of a better understanding of what the law is, how it's applied, to hopefully put you in a better position to stay compliant. One of my big deals is to help you proactively stay compliant so that down the line, hopefully you don't need us in a situation where you're either misclassifying an employee, you're getting sued for retaliation or discrimination on the basis that you have someone who is actually an employee that you thought was an independent contractor. We'll talk through a few of those different scenarios, but my goal is for you to be proactive and to think critically sort of about your business and your business relationships so that you don't end up in a fight with an employee or with the government. So jumping in, I think a good place to start, and I'll go through kind of a few of the basics because it's always helpful to sort of get a refresher. But I think we should start by realizing that really there are only four categories of individuals that we're looking at in an employment context. Each of them have nuances, and understanding these nuances are important. So I wanted to go through them sort of briefly. When we look at volunteers and interns, they're not often subject to traditional wage and hour requirements. That's a whole different issue in and of itself, but that's kind of the way that we're looking at it from a state and federal perspective. While traditional employees, right, are subject to wage and hour requirements. And so what we have is this interaction between state and federal wage and hour law that is really driving this whole thing. The way I like to look at it is the federal law sets what I like to call the floor, and the state law sets the ceiling in terms of wage and hour regulations. So the federal government implements rules, laws, regulations, and then the state of Oregon has the ability to go above and beyond. A good example of this is the federal minimum wage, right? So we have a federal minimum wage, but Oregon's minimum wage is significantly higher than that. So long as they're not otherwise interfering with that federal floor, the state has the ability to go above and beyond. And as we see time and time again, the Oregon legislature chooses to do that. So really the real estate model differs from the rationale for traditional wage and hour requirements, which is why we see these sort of carve outs and see real estate agents, brokers, and people that work in the industry treated differently under federal and state law, right? And our traditional definition of an independent contractor really is a person or entity that's contracted to perform work or provide services to an entity, but as a non-employee, right? And we'll talk a little bit of why there's some differences, but really at the end of the day, you got to pay your own Social Security, Medicare taxes. For the most part, you're considered, sole proprietors or LLCs. You end up reporting taxes differently. You end up doing a whole lot of things differently. And we have this distinction from traditional wage and hour employees, and the underlying rationale, to be honest, is that the model, which a lot of times is driven, by sales, one, but also incentive-based compensation. So, you make a sale, you get a certain percentage of that. And it's so far removed from the traditional, okay, I work 8 hours a day or I work 40 hours a week, and you're going to contract to pay me a certain wage for those hours worked. The model is different, and that's sort of the underlying rationale for having these two different models. So why does it matter? Why does the distinction matter? A few different reasons. The first, right, is money. The government, for the most part, would prefer to have, for multiple reasons, but they would prefer to have people classified as employees. One of the reasons for that, right, is we want people to be employed. We want people to have benefits and entitlements that they wouldn't otherwise be able to take advantage of if they were an independent contractor. I think Oregon sick leave law is a good example of that, right? Employers with a certain amount of employees are going to have to provide paid sick leave to employees. That's a benefit that we want employees to be able to have in the employment relationship and in that context, but there are benefits that are not otherwise available to people like independent contractors. And that's one of the reasons why the government favors employer status. They want people, for the most part, to be classified as employees to the extent possible. The underlying rationale for that, and we can, debate the reasons for this, but really it's money, right? Companies pay payroll taxes, and the less employees there are, the less payroll tax revenue is coming through the door. And the state doesn't necessarily want that to happen. Even though they're getting paid taxes independently, they have a big interest in seeing payroll taxes, FICA, come through the door. And the government wants to share those taxes. So that's kind of their perspective on why they would prefer to have someone designated as an employee as opposed to an independent contractor. For you, the reason why this really matters is the consequences for misclassification. And they're significant. We'll talk throughout about how significant they are, the different ways that you could potentially get into trouble, because as I said, I want this to hopefully be looking through the lens of how do we stay compliant, how do we not end up in a situation where we're misclassifying folks and we're getting in trouble. So it's kind of a general overview, and we'll give examples kind of as we go throughout, but if an employee is improperly classified and no payroll taxes were paid, for example, state agencies are required by law to assess back taxes, penalties, interest, all of that stuff. As you probably know, the Oregon Department of Revenue and the IRS are extremely strict on penalties. I used to do quite a bit of tax work, dealt with the IRS quite a bit, and they're not lenient at all, really, when it comes to interest payments and penalties. You'll end up paying interest backdated to the time of the mistake, not the time that you found out about the mistake, is probably the easiest way to describe it. These claims end up getting super messy. From an employee side, if I'm an employee and I'm misclassified, the most common thing, the most common claims that I deal with are situations where an employee comes back and is asking for back wages, penalty wages, interest, unpaid overtime, all those sorts of things. And I think the risk there is particularly high in real estate, where employees might be working what other industries would consider kind of abstract hours, maybe showing houses on the weekends, or working in capacities that might put you over 40 hours in a given week. So sort of how those claims work, and I'll switch to the next side here, in terms of how this comes up. An example of a claim that we would see often where an independent contractor is misclassified. So it's really an employee, but not an independent contractor. They end up realizing at some point or another that they think that they're misclassified, and those arise, in different scenarios, whether someone put them onto it or they started doing research at home. Either way, they end up challenging their status as an independent contractor with the individual or individuals who they believe are their employers. So what happens then most of the time is they go back and seem to be able to magically recreate or put together exactly how many hours that they've worked over the last, say year and a half, for example. They send a demand letter or something else saying, hey, by the way, you've misclassified me as an independent contractor. I'm actually an employee that is entitled to certain wage and hour requirements under law. And I now want unpaid overtime because when I added it up, I ended up working 50 hours per week over the last year and a half. So I want payment for unpaid overtime. I want penalty wages because you failed to pay me in a timely manner. And then whatever else they sort of want to throw in there. The importance of the distinction is that if I'm an employee, I'm covered by these laws, right? I'm entitled to overtime if I'm a non-exempt employee working in excess of 40 hours a week. If I'm an exempt employee or I'm an independent contractor, I'm not subject to these wage and hour requirements. And so from your perspective, really, I'm trying to figure out a way where I don't have employees, because if I do, I'm potentially subject to that employee coming back for whatever reason and trying to ding me by saying that they're entitled to overtime penalties and all these sorts of other things. There's a couple different tests that we'll look at that BOLI uses to determine, employer and employee status for purposes of determining that specific relationship, and then a different test that they use for determining whether or not you're an employer for purposes of civil rights related statutes, which can get you into a whole different kind of bag of trouble. So here are just some examples of the different ways that this comes up. Unemployment compensation claims, workers' comp claims, income tax reporting and audits, when the Department of Revenue, whether it's at the state or federal level, ends up coming back and going through your books. You don't want to be put in a situation where you're misclassifying people and not paying appropriate payroll taxes. Federal agencies, state and federal agencies, both look into these things quite a bit. And then we have sort of the civil rights related claims. We have claims for negligence, breach of contract claims, and all that good stuff. On the bottom piece here, the breach of contract stuff, now would be a good time to mention, for whatever reason, and I'm, to be honest, kind of shocked how much this comes up. People think that just because I enter into an independent contractor agreement and that I sign it and that they sign it, that makes that person an independent contractor. Just not the way it works, unfortunately. Whether or not a contract that's otherwise supported by adequate consideration and all of that would be enforceable, if it's in violation with the law, it's not going to be enforceable. So think of it this way. It would be like me contracting with an employee to pay them $8 an hour when I know that the minimum wage is, $11.50. I can't contract for something that's otherwise contrary to law. So when the state goes in and starts looking at these things, they're really not going to care whether or not you have an independent contractor agreement in place. You absolutely should. But what you shouldn't do is think that just because you have an independent contractor agreement in place that you don't need to go through this sort of extra evaluation of whether or not that person is actually properly classified as an independent contractor or not. Okay, so for whatever reason, and to be quite honest, the legislature does a lot of things that don't particularly make sense to me, but we have three different tests that we're looking at here. One is under ORS 670-600, and what these different tests do is they're applicable in different situations and to different state agencies. So ORS 670-600, what we're really looking at is the DOR, the Department of Revenue. We're looking at the Employment Department, different board agencies throughout the state. And then with the economic realities tests, and these bottom two ones here are ones that BOLI uses, but they're bifurcated. So the Wage and Hour Division uses one test, and that's in conjunction with the U.S. Department of Labor. And then the Civil Rights Division and the Workers' Comp Division uses a separate test. And what we'll do here is go through each of them because I want you to sort of understand what the distinctions are and why there's a distinction. So ORS 670-600, which may be the one that you're most familiar with, is really talking about, and if I had to peg sort of an overarching theme, both at the state and federal level, for what the government is concerned about with independent contractors, it's whether or not they're free from direction and control over the means and manner of providing services. Because when we think of traditional employer-employee relationships, we think of someone showing up to work, scheduled hours for a certain amount of pay. I know when I'm going to get there. I know when I'm going to go home. I may be entitled to rest breaks, meal breaks, depending on my exempt or non-exempt status. But really, my boss or my employer is dictating the terms of our relationship. And that traditionally doesn't require an employment contract per se, but you enter into an agreement that's otherwise enforceable with an employer with respect to the terms and conditions of your employment. And so with independent contractors, what we're looking at is distinguishing that in its entirety, right? We want the person to be free from the direction and control over the means and manner of providing services. And at the end of the day, where people who misclassify independent contractors get into the most trouble is this prong, right? It's where they're exercising too much direction and control over the means and manner of how an agent, for example, is providing services. You know, you really want to stay away from buzzwords like be here at this time, you are required to do this, you're required to do that. And there's tons of case law on this at the state and federal level. This is something that's been litigated for decades, to be honest. But you really want to look at those two words, direction and control, and think about whether or not on the day-to-day you're exercising a great amount of direction or control over people that you otherwise have classified as independent contractors. And if you feel that way, you should sort of take a step back and think about it. So the second prong here is customarily engaged in independently established business, right? So they're doing their own thing. They're making their own money. They're independently working. They're not necessarily working for me. They're independently working for a business that's been established, presumably, with the Secretary of State or otherwise. We'll talk a little bit later about the legislature's attempt to sort of change this. You probably have heard of this. California just had a huge case that went through that essentially changed this whole thing. We'll get to that, but just keep in mind that. And then we're talking about the licensing requirements. So, think of ORS 696-010, talking about licensed real estate brokers that are, conducting professional real estate activities that are defined under statute. Most brokerages are employers for the purposes of state law, even though for the most part, individual agents are going to be classified as independent contractors. And again, this is something that we'll talk about, but is going to be important throughout. Where we really get into trouble here is that agents at the end of the day are accountable to brokers. And so that really puts a wrench into things in terms of exercising discretion and control over them. And it's something we need to sort of be looking out for. With respect to an independently established business, I wanted to put this on the radar. Again, you may know this just in your due diligence and working in the industry, but this is the test. This is what we're looking at, right? Is there a separate business location? Is the individual bearing the risk of loss as opposed to whoever the principal is? Are you performing services for 2 or more companies within a year? Or you're advertising for soliciting a new business that may be independent? Does the contractor have a significant investment in the business? And then is there an authority to hire and fire assistants, right? So just keep those things in mind. At the end of the day, you have to meet 3 out of these 5 elements under the law. So it's not, check all boxes and we're good. There's a little bit of wiggle room in terms of making this work.
Okay,
Okay.
Chris, we got a question, and
Yeah.
this may be a little bit of jumping the gun because I'm sure you'll get to this, but here is the question. If my husband does work for Oregon West Real Estate, assuming that's a company, my company, is he an employee? He does many random things, placing signs, security for my open houses, mowing a client's lawn before open house, help locate septic tank lid, etc. Employee or independent contractor?
So this is going to be the typical legal answer, but it really depends. It depends. It would depend on sort of a broader evaluation of all of those things. I would have to know more about whether or not there's a specific agreement in place, because, and here's sort of a broader thing to think about, and hopefully this will help a little bit. These are not things that are evaluated in a bubble. So when we go and litigate these cases with respect to independent contractors and employees, we're looking at activities over a large period of time. So just because that may be sort of the job duties that he performs sort of on a given occasion, what we're looking at is that sort of regularly what he does? Does he have any duties outside of that? Are there any promises that are made? How does he get paid? Who pays him? And those sorts of things. And so really it's evaluated holistically over time. And so unfortunately, I'd probably need to know a lot more about the situation to give you a definitive answer on that. I'm happy to chat with you about it anytime, but.
So let's assume those activities that the question laid out did occur over a long period of time. This person has a brokerage, her husband's working for the brokerage, doing administrative type of duties like that, putting yard signs up, maybe replenishing the flyer box, changing out a lock box, a variety of things. How would that impact your answer?
So assuming that was the case, I would lean more towards that employee on the face. And then, again, this is without having all of the information. That sounds to me like an employee-employer relationship. Assuming that you're the one who's paying them, they're performing duties on behalf of the organization and not necessarily for the benefit of themselves, if that makes sense. I'm helping out, I'm doing administrative tasks. And of course, a lot of, real estate agencies and brokerages have people who are doing administrative related work. And those people are in fact employees. So this sounds to me more like an employer-employee type of situation as opposed to an independent contractor situation.
Got it.
Okay. So I wanted to talk real quick about the economic realities test. So this is one of the two tests that Bully uses to determine whether or not an employment relationship exists. And so this is kind of relevant to this last question that we had as well. Whether or not a relationship exists is going to be determined based upon a holistic view of these factors. And the reason that I keep using the word holistic view is because it really is different, and it's more difficult really to interpret than a situation where you say, okay, I have to meet these 5 requirements and I have to meet each and every one of them. So if I don't meet one of them, then I know I don't meet the test. Here, when we have a holistic view of everything, it means, okay, this could count a little, the next factor could count a little more, this could count a little less. We're essentially adding them all up and then doing a balancing act to make a determination at the very end of whether or not we meet the test or not. So we're looking again at the degree of control exercised by the employer, the extent of the relative investment of the worker or employer, the degree to which opportunity for profit and loss is determined by the employer. That's a big one, right? The skill and initiative required to perform the job. the permanency of the relationship, and that really comes down to, is the employee at will? Can I leave at any time? And the extent to which the work performed by the worker is an integral part of the alleged employer's business. And so for each sort of separate agency or brokerage, these factors are going to weigh a little bit differently depending on how many people are working there. What is your typical structure like? Is it a come and go sort of environment? Are you allowed to work from home? Are you required to be in the office? And all of those things are going to go and fit into one of these categories in one way or the other. And at the end of the day, Bully's going to add them up and look at them and say, okay, do I think this tips one way or the other, right? So let's take just an example. Number 3 here, which I mentioned is a big one. The degree to which the opportunity for profit and loss is determined by the employer. So if I have an agreement, right, where I'm listing real estate, for example, on my own, and my basis for compensation is determined by how much I bring in. It's not determined necessarily by the employer, but rather it's based on my performance. Okay, that's going to weigh in favor of you being an independent contractor as opposed to an employee. A normal worker that works 8 hours a day is not really getting paid on production, right? They have performance expectations and things that they're supposed to do, and of course they're evaluated. However, they're not being paid based upon, for the most part, I get 5 things done, I get X amount of money in exchange for getting those 5 things done. To whereas if I'm selling a house, for example, I'm getting paid based upon that sale. I'm not getting paid on the basis of performing X amount of activities throughout the day in a situation where I know that I'm getting a certain amount of compensation in exchange for that. That's not to say that you can't have a set commission structure, right? That would be common. But what you want to look at is how that commission structure is set up and who has the most autonomy, the employer or the independent contractor in that particular situation. So that test is used to determine whether an employment relationship actually exists between the two parties. The separate test that Bully is going to use is this right to control test. And this is used to determine employer status for the purpose of civil rights laws. And this is extremely relevant for employers, and this is probably where I see independent contractor status, employee status get litigated the most, is in the context of, okay, do I have an actual cause of action to sue my employer because they are my employer, right? And so I'll talk in a minute about that. But the 4 things we're looking at, and again, you'll see that this top piece is really the overarching theme of this whole deal. Right? Is there evidence of a right to exercise control over the employee? Okay, the second piece is the method of payment. How is that individual getting paid? So you see kind of there's some parallels between the 2 tests, but they're independent and distinct of each other. The furnishing of equipment, right? Am I working to make sales off of equipment that I own? Am I going into the office using a computer or a laptop that's not owned by me? Are you furnishing me equipment? And then the right to hire or fire that person. So here's why this is particularly important in the context of employment-related claims. If I'm a principal broker, for example, I want to be particularly sure that I'm in compliance with this right to control test. I don't want a situation where I have people that are classified as independent contractors who are otherwise as employees. The reason being, the employee then has a cause of action for you because the provisions of Chapter 659A and all of the other employment laws are going to be attached to you. So if I'm an independent contractor, for example, and I want to bring a claim for age discrimination or workplace harassment, one of the requirements, right, is that I actually have somebody to sue. So if I don't have an employer that I can sue for an action like this, I'm not going to technically have a cause of action under something like ORS 659A 199, which says it's an unlawful employment practice to do this or an unlawful employment practice to do that. Not that anyone should be engaging in any of that type of behavior at all, but in a situation where you have people that are employees, it inherently comes with greater risk, because those employees then can turn around and bring claims against you as an employer, to where it is much more difficult if they're classified as an independent contractor to go back and bring claims. And so I want to put that on your radar because it's extremely important. We see this situation all the time where there's an issue over whether or not someone who thinks that they're an employee who has otherwise been previously classified as an independent contractor has the ability to sue their boss under Oregon's workplace discrimination laws. And we get into a big fight about whether or not that person is actually an independent contractor or they're actually an employee. Because what the employee wants to do in that situation is impute responsibility onto their boss and essentially make them pay. So be aware of that. Think about it.
Hey, Chris, can I ask you if you can provide an example under the economic realities test, the last bullet point, extent to which the work performed by the worker is an integral part of the alleged employer's business. Can you give an example of, perhaps in the real estate context, where that might apply, or other businesses, how that's interpreted?
Yeah, absolutely. So this is one of those pieces that the legislature really is attempting to change through the new legislation. So when we're looking at the extent to which the work performed is an integral part of the alleged employer's business, what we're looking at is, do they do the same thing? Most of the time, the answer is going to be yes. So in a broad context, this particular prong is going to weigh in favor of someone being classified as an employee as opposed to an employer. And the reason, or as opposed to an independent contractor, excuse me. And the reason being that in a typical brokerage example, if I have a principal broker and I have people working under me, we are all engaged in the same business, right? We're all, for the most part, engaged in some facet of real estate. It may be to different points in the pipeline, whatever it may be, but we're all engaged in the same exact business for the most part, or at least that's how the law is going to interpret it. And so the key operative word in there is integral, right? Or integral, or however you want to pronounce it.
We know what you meant.
Okay. The key word in there is integral. And the reason is, okay, assume for the sake of argument that we are engaged in the same business. So otherwise, under the statute, we're going to say, okay, that clearly weighs in favor of this person being an employee as opposed to an independent contractor, because we're all engaged in the business of real estate. But does the principal, for example, how much is their profits per quarter, per year, whatever it may be, determined based upon the work that people who are working under them are doing, right? Is the fact that we're able to keep the lights on from year to year based upon the work that these independent contractors are doing? Or am I, as the principal, independently financially sufficient enough that really my business that I'm running is not dependent upon the work of the people that I have working under me as independent contractors? And that's a little bit complicated. And again, we like to use these sort of ambiguous words, and then we get to go into court and argue about what a single word means. And
lawyers love ambiguity.
Yeah.
Okay, thank you.
Okay, so this is probably no surprise to anyone, but I, of course, wanted to bring it up. This is Oregon House Bill 2498, which was the legislature was looking at last year. From my understanding, this is going to keep coming up. I know for a fact it's going to keep coming up. I just don't know for a fact whether it's going to pass. It's really going to be determined by which carve outs they end up putting into this. I think the real estate industry is probably a perfect example of an industry that should be carved out in the event that they were to pass another law. I know for a fact also that's something that they're looking at. I know that the real estate industry has a pretty good lobbying arm for the most part that was fighting against 2498 last time it was at the legislative level, and I would expect to see the same in the future. Really the operative question to boil down what the legislation is asking, right, is they want to change the operative test, and they want to ask the question, is the worker's service outside the usual course of my business? And the rationale on one side is that, okay, typically if I'm hiring an independent contractor, think about like just a general situation. So if I'm at my house and I'm engaged in the practice of law and I have an issue with electricity, I'm going to call an electrician, right? That electrician is going to come over, say they have a sole proprietorship, they're going to help me fix something. I'm not engaged in electrical work, so we don't have any sort of issue there, right? And so the proponents of having a test that says, is the worker service outside of the usual course of my business, is that whoever I'm having perform independent contractor services, their services should be far removed from what I'm doing. On the other side of that, it's big trouble, right? It's essentially trying to destroy the independent contractor relationship in the context that we see it in real estate. So if the test really is the worker service outside the usual course of my business? Well, the answer is going to be no, right? If I have independent contractors that are working under me in a brokerage type setting, they're going to be engaged in the usual course of business, and I'm going to be engaged in the regular course of my business. And whether or not there are nuances between what houses we're showing or what we're doing on a day-to-day basis, we really are engaged in the real estate industry. And so it's effectively going to eliminate that status, and that's not good, obviously. I don't think that will end up being the case. I think even if this were to pass, there will be significant carve-outs for particular industries, and I think real estate will be one of those industries. The context of where this is coming about, and you may have heard of this as well. So California just passed a similar type law. Well, not a law per se, but there was a significant case. It was Dynamex versus Superior Court. This was in April of last year. But essentially what happens, for context, is an employer decided that they were going to attempt to classify, and this employer was engaged in the trucking industry, that they were going to attempt to classify, I think it was 16 of their truck drivers as independent contractors. The issue is, right, and just think about this practically, a truck driver that I'm telling has to be here at a certain time to pick up a delivery, and they have to be somewhere else at a particular time. I'm setting the terms and conditions of their schedule, right? They really don't have any autonomy or control over the fact that I'm telling them that you need to go from point A to point B in a particular period of time, and this is what you need to bring with you. So wage claims were brought by these delivery drivers who were classified as independent contractors, right? These particular folks didn't have other drivers. They weren't doing delivery work for other companies. They worked exclusively for these people. And so what the court did in that case is develop what they call the ABC test. And I would not be shocked if we do see subsequent legislation that passes in Oregon for the courts to adopt a similar test, and that's why I wanted to put it on your radar. But the test is, it's three-pronged. So one is the worker free from direction and control in performing the work. So that's nothing new, right? We've seen that. Worker performs work outside the usual course of the hiring entity's business, right? The tough one here is prong three, and that's where the issue is going to be, right? The worker is customarily engaged in an independently established trade of the same nature as that involved in the work performed, right? And so if I'm not engaged in a trade that is independent from the work that my alleged employer is performing, then we're in trouble. It's essentially exactly what the Oregon court is looking at, right? Is the worker's service outside or independent of the work that I'm performing as an employer? So this is now, I mean, it's live, it's legitimate in the state of California. You've probably seen this on blogs, boards, and all of that, depending on how kind of closely you follow this. But it's causing major issues. It's impeding people's ability to, one, make a living as independent contractors, and then employers' ability to even hire independent contractors. Because if they're engaged in the same sort of services as the overarching company or brokerage, then there's going to be a huge issue. And so, as with all new sort of legal opinions, it's going to be a while before we actually see how this plays out. My anticipation is that it's going to be appealed to some extent, and I would not be shocked to see pieces of it either carved out or overturned. I think it's extremely way too broad. I'll not sit on my soapbox and talk about how I don't think it's fair, although I'm happy to discuss that with anyone any other time. There's a lot of things I think are unfair, but outside of our scope. So this is just kind of something I wanted to mention too, because I think it helps give practical context to these issues that we're thinking about with sort of independent contractor status and all these sorts of things, right? And it was helpful for me, I think, when I first started litigating cases with respect to independent contractor status, to understand what the rationale was and what really we're looking at. And so this is just an example for you to take a look at, but I was kind of surprised. So nearly 70% of on-demand drivers, right, work for both Uber and Lyft. I use both. I typically don't care. It's kind of like get me where I need to go in the shortest amount of time. But it kind of helps give a little bit of context to the application of the Oregon test and this new California test. I don't know. I know there's separate licensing requirements, but I would assume at least some people may be in this group do real estate in California as well, which is one of the reasons I wanted to include it. But in this scenario, right, the workers regularly engage in independent occupation or business of the same type that they provide for the company. So technically they're fine, right? And it also helps with the application of the Oregon test. So we have this kind of carve out under 670, 600C, where the person provides contracted services for two or more different people within a 12-month period. And so really what they're doing is they're performing the same work, but they're performing it for two different companies. And this is just kind of interesting how this has come into play and shed some light on, one, the new California test, and then the application of the Oregon test as well, because it gives an example of how someone can be performing work technically for two different companies or two different projects per se, or listings, if that's an easier way to think about it, and still be properly classified as an independent contractor. I don't know how much more time
So
we have.
do you, back to the California law,
Yeah.
since it's on our radar. As a result of this case, the California legislature passed some legislation, right, covering this. But fortunately, there is an exemption for realtors. California Association of Realtors has a very large PAC and high influence on the legislature down there. And so our lobbyist has told me we absolutely will see this in 2020 and 2020. It's never going away. I mean, there's a strong coalition opposing this legislation. And I shouldn't say this because it might jinx it, but I feel fairly confident that realtors, real estate licensees will always, not always, but will get a carve out again. But we got to be prepared in the event that doesn't happen. So I know your last slide is best practices. So tell our members what they should do to help prevent being classified or getting called out for misclassifying their brokers.
So I agree 100% with that. Well, I'd say 99.9% because I never feel comfortable giving 100% read on anything that I think that the legislature's going to do in a given instance. But I would agree. I can't see a situation, and this goes back to what we talked about sort of at the very beginning about the underlying reasons for distinguishing between a normal employee and an independent contractor in the situation of a real estate agent or broker. It's so distinct from your normal employment relationship that I can't see a situation where there's not an existing carve out for things like that. It's a viable, industry that the model for payment is just distinct. And so it would make sense, and I'd expect it to continue, that the two are independent of each other. However, in any instance, it doesn't matter that we can't, doesn't matter that we're not going to be able to rely on that to not get in trouble. So here's sort of my 4 main takeaways. Use an independent contractor agreement, even for smaller practices. And I know I had mentioned this earlier, that independent contractor agreement is not necessarily going to get you out of liability. However, a contract is always better than no contract, right? So it doesn't mean that it's dispositive, and that if an agency or an auditor comes in and looks at things, that they're going to say, oh, you have an independent contractor agreement in place, and therefore you must automatically be classified as an independent contractor, or that you're telling the truth. Not that anyone is ever intentionally trying to misclassify people, but they're gonna look at an agreement and do an individual evaluation of it. But you should have an agreement in place.
It's just one more thing to substantiate their defense, that they're independent contractors. But in and of itself, it's not going to protect them.
Mm-hmm. Absolutely. Pay attention to those and make sure that they're valid. One thing that we see a lot is that there's agreements that are entered into that are independent contractor agreements, but they're not very good independent contractor agreements. They don't spell out sort of what the scope of the service is. I'd be pretty careful about defining what the scope of the project is, defining what the compensation structure is for the scope of the project, and then making sure really that there's, adequate consent and consideration for the contract. Aside from getting in trouble with regulatory agencies, and aside from sort of wage and hour claims, we had mentioned earlier that there's a huge liability here for breach of contract claims. I mean, this is not uncommon in the real estate agency or real estate world, where we have breach of contract claims for a million different things. And that could be related to construction. It could be related to, something's wrong with a house, whatever it may be. With independent contractor agreements, it's really the last place we want to get in trouble, because we have all of these much larger contracts that we need to worry about with respect to real estate. Second best practice here, be aware of situations where employees and contractors are doing the exact same work. And there's not a lot that we can do about this particular prong. As I mentioned, I very quite honestly think that it weighs in favor of folks being classified as employees as opposed to independent contractors. If you have several people in an office engaged in the real estate business, and I'm doing the exact same work as my boss, that factor is going to weigh in favor of me being classified as an employee. It doesn't mean that it's going to be the dispositive factor, because there are other things, such as a lack of exercise or control over the terms of my employment, that might otherwise weigh in favor of being an independent contractor. But just be aware of situations where you have folks that are doing the exact same work, and that's both employees and employers, and then contractors with their bosses or principal brokers. The longer that a contractor has worked with you, the greater the risk. That's just sort of the reality of it. And the reason I wanted to bring this up in terms of best practices is that you should go back and revisit or reevaluate that relationship periodically in the event that you have someone that's worked for you for a really long time. Because one thing that we see is we have an agreement that's entered into by a couple of parties. say it's a principal broker and then someone that works under them, and say the agreement is for 3 years to provide a specific amount of services. 5 years down the road, both parties realize that technically the agreement is expired. They never went back and redid anything because by this point they're comfortable with each other and everything's all good. And so why go back and revisit it? Or, maybe you forget, whatever the case may be. There's risk associated with that. The longer that someone's been with you, the courts are just tending to assume by human nature that that relationship is evolving, because we think, again, as independent contractors, someone who's doing something for us on a short-term basis, sort of that example that I gave of, I call an electrician into my house to help me fix something and then they leave, right? If that electrician is still doing work for me 5 years later and is doing it, 5 days a week, it's a little bit different. And so if you have long-term folks that are with you, the best practice is just to reevaluate that relationship, make sure any written contractual agreement that you have in place is valid and is not sort of expired to where you're sort of left with, okay, these are my job duties, take with it what you will. So last best practice here is to collect and preserve evidence of contractors' advertising efforts and work with other companies. So if you have folks that are working under you and they're doing all of these independent things, keep an eye on it. And this is really sort of a matter of building evidence, to be honest. In the event that that person ever challenges that they were incorrectly classified as an independent contractor, can you go back and say, this person was advertising independently. This person was performing work on behalf of either other organizations or projects that were outside of the scope of what I'm doing, or otherwise evidence that they have autonomy in what they're doing on a day-to-day basis, right? Now, I know that's a little tricky because I've been telling you that you should not be exercising control over what they're doing, but exercising control over what they're doing and keeping track of what they're doing are two sort of different things. And what I don't want to have happen is you put in a situation where someone after 4 years says that they've been misclassified and you really don't have any record or idea of what they've been doing for the last 4 years. That's not necessarily common, but it is important, particularly in an employment world right now where things are becoming increasingly more about what documentation an employer has or doesn't have. There's an increase in the statute of limitations that just went into effect with respect to employment discrimination claims that extended the statute of limitations from 1 to 5 years, which is absolutely absurd. That's all I'll say about that. But the takeaway is we're going to have to start documenting the hell out of everything. So make sure that you're preserving the records that you need to be preserving. You're collecting logs of what's going on so that in the event that anyone ever did come back and say, hey, you misclassified me, I'm bringing a wage and hour claim against you, for example, which statute of limitations is less on that. You're going to have the ability to get back at them with the documentation that you've collected.
Okay, there's a question that came in, and of course you can guess by the nature of the question, it's from an attorney. Does Realty, and if you're not familiar with this case, does Realty Group Inc. versus the Department of Revenue have any bearing on this issue? Are you familiar with that case?
Is this, I don't know how quickly they can respond. Is this the mortgage loan originator's case?
You heard the question back to you, Mike, so we can always handle it offline. This may be beyond the scope of all of our listeners. So if you
Is it in the North Star case? No?
No. We'll deal with that offline, but can I back up 1 second? You said the statute of limitations was extended from 1 to 5 year on employee harassment cases only?
Discrimination related cases. So there's a category of what the legislature is now calling, protected discrimination, and that includes not only workplace harassment cases, but discrimination, cases, including, protected and perceived protected classes, age, race, anything you can think of really in the employment context is going to be extended now from 1 to 5 years. Wage claims are different. Typically, we're looking at a 2-year statute of limitations on wage claims. But the discrimination claims are relevant because if indeed you find yourself in a situation where these folks are employees as opposed to independent contractors, and they do file some sort of discrimination or harassment claim against you, we're looking at them literally being able to file that claim 4.5 years down the road. And so going back to the importance of documentation, most people can't remember what they had, for lunch last week, let alone what interaction may have occurred 4.5 years ago at your place of business. And so the importance of documenting what's going on in the workplace, regardless of whether someone's an independent contractor or an employee, if they're under your roof, so to speak, you should be aware and in tune to what's going on, and you should be documenting things so that if someone does try and impute some sort of employer liability to you down the road and bring some sort of discrimination or harassment claim, that you can go back and look at what happened because you documented it and you put it into a file, as opposed to now we're going back and guessing about what may have happened.
Our members are definitely the masters of documentation. They know in their transactions, it's all about documentation. Well, thank you, Chris. Based on this webinar, I smell a subsequent webinar coming, if Chris is willing to do it, on best practices on what an independent contractor agreement should look like. Let's talk about terms. We don't want to necessarily draft it for them via the webinar, but give them an idea for our members, brokers who currently have independent contractor agreements, to go back and look at terms, and then to help some of the principal brokers implementing the independent contractors to make sure the company is protected as well. So maybe we can do a webinar first quarter of the year on that.
Yeah.
I just locked him in online. So.
Yeah.
Okay.
No, I'd love to do that. And again, these things independent contractor agreements are different than our typical employment agreements. And there's some nuances in there that can, ultimately make an agreement not enforceable or void if we're not doing it correctly. Yep. So
very good. Thank you. This was really helpful and great information. Thank you, everyone. Have a good day.